All right. Hello, everybody. Thank you very much for joining us on this exciting webinar about the future of EB5. We have some great people who are very knowledgeable about the industry here, and who certainly have their hooks into the legislative process and what's going on and can provide us some useful updates. So with further ado, everybody I think knows who I am and who our law firm is, so I won't waste everybody's time. But I will let our panelists introduce themselves. So Kurt, let's start with you.
Thanks, Mark. My name is Kurt Royce. I founded a company called Eb5 Marketplace. It hosts about a dozen projects right now, Eb5 investments, all of which we've thoroughly reviewed. We look at the strengths. We evaluate for the strengths and the risks of each of the investments. We even have a rating score for each investment, all designed to help investors make as an informed decision as they can when they're considering an EB5 investment. Glad to be here too, Mark.
Okay.
Thank
well,
you.
Thanks for that. Awesome. Matthew?
Yeah, thanks everyone. Thanks for joining. My name is Matt Hogan. I'm Vice President of Project Development for CMB Regional Centers. CMB, the company I work for, is one of the largest active regional centers in the industry. We've been around for just about 24 years now. I think next month we'll celebrate our 24th anniversary. We've worked with many clients, over 5,800 families from over 100 countries around the world. We have a lot of experience, and we've been able to help those investors achieve their goals in EB5. And we've had many projects. We're now over 75 EB5 investment partnerships. We've never had a project denial. We continue to maintain that 100% success rate in that regard. And we're glad to be here today, strong supporter of the industry in many ways, and looking forward to the panel. Thanks a lot.
Let's see.
Good morning, everyone. Mark, first of all, thank you for having us over here. And as far as my background is concerned, my name is Asif Chipa, and I'm the Managing Director for First Pathway Partners, one of the leading regional centers in the United States. And as just Matt said, we are also there in the same industry and helping the immigrants who are just willing to migrate to the United States on the EB5. We had successfully completed, so many projects in past, and we are 100% supporter of this industry, an exciting industry, and we are happy to be here. Plus, as far as the personal background is concerned, I myself, a fully redeemed investor who migrated to the United States on EB5 only. So I've been through this entire channel by myself. I applied back in 2016. So I'm very happy if I can provide some assistance in this particular webinar. Thank you.
Right. I've known Asif. We've known each other for what, probably 7-8 years.
Absolutely, Mark.
Yeah, great. So let's start off. We've got a few things to talk about. We wanted to talk about this sort of rumors in the market, lawsuit bearing $500,000. Also, we want to talk about the bills that are pending and potential legislative changes. And several people on this panel have lobbying support that I don't really have, so would have a much more up-to-date position on that. And then let's talk about sort of consular processing and what happens after I-526. And then next week, we're going to do a completely separate webinar on how to maintain your permanent residency once you have it, because a lot of people are confused. And just as a note, a lot of people I'm coming across don't have state IDs. They don't really have a registered address in the United States. We'll talk next week about why that's a big mistake if you're a conditional resident. But let's start from the top. So Kurt, what's all of this? What's the truth behind all of this talk about a possible window of $500,000 again? And, is it all 100% just hype?
Well, unfortunately, I don't think anyone knows the answer to the question, Mark, and that's the hardest part. There does seem to be a judge who's entertaining the throwing out of the new regs that came out November 2019. I think that the chance of it happening are slim to none, but I also understand the desire to be prepared if it should become available. So I would certainly encourage people to do whatever they can. If the $500,000 is the amount that they can afford, and if they can put it in a position where it's ready to be deployed quickly into a project. I do know a number of issuers who have gotten with their securities counsel and asked them to draft addendums to their documents so that they can accept a lower investment amount. And that's a little tricky. They got to work through some issues related to treating all of their investors equally. And so they're working through some of those issues now. But, it's one of those things where it may not be very likely. I don't think it's very likely.
I think everybody agrees that maybe it's not very likely, Kurt, but you look at lots of projects and you analyze those independently for clients. What do you see a lot? You said that there's some people talking to Securities Counsel. If this does happen, do you think people are going to have good options available?
Well, I think it's a multi-step thing, Mark. I think even if the judge comes down and says the regs were not properly implemented, they may give the Department of Justice some time to appeal. By the time the new bill, the Reform and Integrity Act, gets finalized, it seems to me like that's going to override a lot of this stuff. So even if we do get the judge to say, yes, the Chad Wolf was installed incorrectly, and his determination of these
who's Chad Wolf, just for anybody who doesn't know?
Oh, sorry, yeah. So Chad Wolf was evidently installed as the Department of Homeland Security's chief, but the judge is determining whether that installation was inappropriate, and if so, maybe his rulings, the pronouncements that he made while he was there, should be negated. So that's the argument that we should go back to 500,000. Like I said, I don't think this is going to be, we're going to get a court decision and suddenly they're going to throw the doors open to this possibility. I think it's just that it would be the first step in a sequence of steps that would need to happen for this $500,000 change.
Matt, I know you've looked at this carefully too. Do you have anything to add? I think to Kurt's summary.
So first of all, I completely agree with everything that Kurt said. It does seem like the judge is entertaining it. I would throw a caveat in there, though. Some of the articles that have been written on this that people have kind of, gotten excited about, you got to look at the author of some of those articles. Some of them are actually written by Greenberg Tourig, who is actually representing Berry in this suit. And so obviously they're not going to paint a picture that looks bleak for their suit. So that's something that you have to kind of take into consideration. There is a chance. I'm not going to say there's not a chance that it could go down to 500,000. I think what a lot of people think is that right now, I think there's 19 days left, right? And the judge, I think, is a pretty good chance that the judge just runs the clock out on this, because once you get past June 30th, if there is no extension of the program, the case is moot. There's not really a reason for the judge to make a ruling in that regard. But for people who want to be prepared, I think there are going to be good options out there. I would tell you, CMB's Group 79 offering is out on the market right now, and it is designed to take investors with partial investment funds. And so it can accommodate. It's already structured. It's been available for a couple of months now. It's actually out there, and it can accommodate investors who want to move forward with a $500,000 investment in the event that a ruling comes down in Bering's favor while the program is still authorized. So that's something that they could look at. We can answer any questions that they have about that. It's a strong project. It's a developer we've worked with many times before. It's the development and construction of a Class A logistics center. I can tell you that it's pre-leased. Amazon is the tenant. They've publicly announced that. So it's a really strong opportunity. Reason why I think it's also interesting for investors is if they can do the $900,000 investment, and they want to start their due diligence on that, it's something that they can do now, and then they can wait, to see if there's a $500,000 opportunity. And if not, they still have the opportunity to move forward at $900,000. And so I think, to kind of add my 2 cents to that, I think there are going to be good opportunities out there. However, probably unlikely that we see that Bering suit receive a ruling between now and June 30th.
Yeah, I think a lot of the attendees on this are from India. And, we've been doing Indian Eb5 for almost a decade. We've never had a source of funds problem or denial. My observation is to do the source of funds work properly is going to take time. So I agree with Kurt that you're almost out of time. To get a case properly pulled together and filed, you better start, if you want any shot at all, if there's a window, you better start doing it right now, immediately today. And even then it may be too late. Do you think that's fair, Matt?
Yeah, I do. I think the people who are going to look at that opportunity are the people who have already kind of started to go down that path, that are interested in the $900,000 opportunity, that are capable of doing the 900, and who have started to do source of funds work for that 900,000. They may find themselves with this unique opportunity to do a $500,000 investment. But if you haven't started now, unless you have the cleanest possible source of funds and an attorney who's ready to kind of drop everything and get after it, I think it will be a little challenging to get that done in the short period of time we have left.
By the way, I see the number of attendees is still rising. If you have a question, please do type it, and we will ask it to the panelists at an appropriate point as we move through these proceedings. Part of getting ready is, you have to have your source of funds ready, and then you're going to have your money most likely in America if you want to move as quickly as you can. It can be in your lawyer's client escrow account, or even a family's account, or somewhere, but it's going to have to be sent to the regional center very fast if this opens, and sending it from India can cause delays. So, I would certainly look at getting your money in America. I would certainly look at getting your package together. Our firm have a Chicago office, which is where the USCIS lockbox is. And in the past, I think we've hand delivered stuff to that lockbox, which can actually be done, even though it's a lockbox. So, things like that might make this a possibility. So here's a question, and Asif, seeing as you haven't weighed in on this, let's see. Why is the possibility of $500,000 only possible for a short window of time? So Matt, I'll let you answer that, unless Asif would like to say this and add some words on this topic.
Sure. I mean, why it would only be available for a short period of time is because, even if there's a ruling today, there's only 19 days left of authorization under the current Eb5 program, or Eb5 Regional Center program, that is. So if there's a ruling today that repeals the regs, you only have 19 days. And I think most people expect that the USCIS, the government, is going to immediately appeal that decision and request a stay to keep the regs intact. So, whether it could be shorter than that 19 days. It's the speed at which that process could take place as well as something.
You're talking about the expiration. I mean, if we see new legislation, and we'll talk about that in a minute, if we see new legislation and the amount were to be lowered, would you expect them to amend the new legislation to put it straight back up to 900,000?
Yes, and that seems like a no-brainer. I think the people pushing, Senator Grassley and Senator Leahy were pushing to increase the investment amounts through legislation with every piece of legislation that was introduced before the regs went into effect in 2019. And so if we do see this bearing suit have success, I think that they are certainly going to just kind of codify the regs in their legislation. So,
Kurt, I'll come back to you with another question on this topic that's come in. So this question says, the chances of 900 to 500 ? If we start investing now or I guess working on 900,000, and by some small chance it comes through at 500, that's not exactly what was said, but is there some way to avail ourselves of the 500 balance?
Yes, I think that Matt brought up a scenario where there are regional centers that are accepting partial payments. So I believe the rules are that you must make your full $900,000 investment before your I-526 is approved. And with approval times taking 1.5 to 2 years, you could make a $500,000 investment. And if the rules change, and again, I would want to know which deal we're talking about. I want to know what documents we're referring to, but it would be likely to me that you would be getting into a deal where it was clear that if the regs were changed, your 500,000 could be applied to under that scenario. But of course, if the rules didn't change, then your 500,000 would need to be topped up over the next 1.5 to get to that $900,000 level to satisfy the minimum investment amounts.
Right. And then Asif, you've been through this. Maybe you have to think about FEMA too. 900,000 is a lot of money to squeeze through FEMA. If you're doing partial payments or 500, it's a little easier, right?
Sorry, what was that?
I said it's a little easier to get $500,000 through FEMA if that's sort of the first
any, of course, any given day, and that's what exactly happened back in 2019 when the amount was it was announced that the amount has going to go up to $900,000 from November 21st, 2019. So we witnessed so many rush from the cases from India, and we did lots of transfer by the end of 2019. So it's any given day, like the transferring $500,000 because we have got the LRS, limitation.
Sorry, actually, when people are using terms that that someone might not know what they mean, I'm just going to ask. So LRS, what is that?
Liberated Remittance Scheme.
Okay.
That's the RBI law that the individual person can remit $250,000 per year per person. So that's the LRS, okay. Liberated Remittance Scheme. And answering to the main question that you were discussing to Matt, because I unfortunately couldn't get a chance to talk about it. Said yes, that's as far as the amount goes up to goes to $500,000 again, right? As Kurt rightly mentioned, that lots of projects are getting prepared and they are preparing for the documentation, amended documentation for the $500,000 project. And as Matt says, that already have the project, same as First Pathway Partners. I can proudly say that we already have the project available, for the $500,000 if the amount goes down to $500,000, we are ready to accept that fund in order to, Matt rightly mentioned that whatever the time frame is going to be, it's going to be limited and it's going to be, less than 18 days or 17 days or 16 days. So that's the way to, prepare yourself with the full $900,000 preparation. And if you get an opportunity of the $500,000 and entering into the particular and rightful project, that can be the opportunity. And because the amount goes back to $500,000, I completely agree with both Matt and Kurt that the chances are slim to none.
So there's a question here that's slightly off point, but let's take it. You've been through this process, so you're well positioned to answer it. The question is, if LRS is $250,000 per person per year, how does one transfer $900K to the regional center?
Well, as far as I'm not sure about the latest development right now, what's going on in India, because it's been quite time. But if I give you the example of, previous experiences. So, for example, being a petitioner, I was there who filed petition in $500,000. So I have got 3 or 4 main source of fund, and all the funds has been first of all approved by the attorney, and then the fund is lined up in one particular account, and from there it was equally distributed to my wife's account or my children's account. And from there, I have to utilize a $250,000 remittance, limit. So in my case, I did $240,000 from my account, $200,000 from my wife's account, and $60,000 from my daughter's account. Even though she was at the time of she was 10, but as per the RBI terms and conditions at that time, right, I was able to transfer the funds. In the case of $900,000, maybe we need to do the same practice, but we need to follow all the RBI guidelines and the law, right? Because right now, as we are facing not only the remittance, but the government has imposed the TES or TCS, something like that 5% tax on the transfer. We need to take into that consideration. So it's always better, the attorney, the FEMA regulation, as well as the RBI guidelines. It has to be the combination of all three, and in order to make the right decision and drive the remittance. So you cannot be any glitch as far as the remittance is concerned.
Yeah, we've got various ways of using escrow accounts so that people can be FEMA compliant and Eb5 compliant. With partial payments, you have to be very careful with. We're talking about partial payments and you can use them. And of course, as usual, Kurt's 110% correct. But the details of how you do that has to be quite carefully done.
Absolutely.
There's quite a lot of questions, actually, there's several questions coming in about choosing projects and fraud. And is there going to be any change? So as this is about the future of Eb5 and regulations, perhaps, we can talk about some of the pending regulations to help add some safety to the industry, or an effort perhaps to add some safety to the industry, and talk about sort of project fraud detection in that context, and what it is now and how that might improve. So Kurt, let's start with you on that, because this is something that you do. Perhaps you could tell us about some of the pending legislation, and I'll let Matt and Asif talk in more detail, and how that might help investors who are concerned about fraud detection, or whether it will, and what other steps they should take.
Sure. So some of the rules changes affect petitioners who've already filed and may have trouble with their regional center, be having issues. So I won't touch upon those. I think most of the people who are listening are probably interested in making an investment and maybe aren't already in the process. And I'm actually not as familiar with the rule changes for petitioners already in the system. The ones who are considering making an investment, the Reform and Integrity Act really normalizes the Eb5 security requirements. So Eb5 inadvertently, maybe intentionally, avoided most securities rules by having the issuer represent their offering directly to investors. And by doing that, there was no oversight from the Securities and Exchange Commission, nor the body that the Securities and Exchange Commission uses to monitor investments and what's being said, what disclosures are being made. So this new bill really puts upon the regional center a lot more responsibilities than they've had in the past. Now, a few regional centers like CMB already work with a broker-dealer. And so they've been following these rules. So I think what it does is it really kind of levels the playing field to quite a bit to making sure that as an investor, you know that all of the disclosures of the risks are being made. You know any conflicts of interest. These are all the things that we try to bring out in our due diligence. So for our investors, it really doesn't change much. But I think you can, as an investor who wants to work directly with a regional center, have some comfort to know that you're going to know everybody who's getting paid on the deal, whose interests are not aligned with yours. So off the top of my head, I can't think of specifically, Mark, what other rules, but it will bring all of the behaviors into the normal way that securities transactions are done, and it will make the regional center responsible to certify that all those things are being done. And in the past, the regional center, to a large degree, hasn't had any accountability at all.
When you say this will bring, is this a certain thing to go through, or is it in negotiation, or what's the status of this?
You know, I don't think that we'll have an Eb5 program, if a regional center program, if this bill doesn't pass. Now, I could be wrong. I mean, I've been looking at some of the old Capitol Hill committee meetings, and I do see, and I also have had some conversations with Leahy staff, and they do imply that they are open to some negotiations. And I think that maybe what they mean by that is maybe the differential of 900 to 1.8, maybe that's too far. And maybe these urban areas should be able to compete at a more reasonable level, maybe at 1.35 or something like that. So there may be some adjustment, there may be some negotiations to give the urban areas a better shake than they're getting today in the bill. But for all intents and purposes, there's no way we're going to have an Eb5 program if Grassley and Leahy don't get the reforms that they're demanding. And frankly, most of the people in Congress think they need it too. Whether they know what it means or not, I'm not so sure. But they want to know that this program has been reformed. And that's what this bill is essentially about.
Gotcha. Matt?
Yeah, I completely agree with Kurt. You know, a couple things on the legislation. So, you know, obviously there's some, in my mind, things that are really exciting about what's happened with the legislation. First of all, not only do you have the Senate bill that's been introduced by Senators Grassley and Leahy, but you have a House companion bill that mirrors that bill. That's the first time we've had that, you know, since this talk of legislative
Let's
change.
just ask a little sort of civics 101 question here. When you say a companion bill, what does that mean, and why is that important? Bearing in mind that, you know, people are on this from foreign countries and might not be familiar with the constitutional process.
Sure. So in order for a bill to become law, it has to pass both chambers of Congress and the U.S. government. So it has to pass both the Senate and then the U.S. House of Representatives. And sometimes you see the House introduce bills, it'll pass in the House, and then there's an iteration of that bill that's then moved over to the Senate. This one started a little differently. It started in the Senate, and now it hasn't passed the Senate yet, but an iteration of that same bill is in the House. Why that's important is because it will expedite that process. If it is brought to a vote in the Senate, you'll have essentially the same bill brought to a vote in the House, or hopefully brought to a vote in the House, with very few changes because it already exists in the House. One thing I would tell you is that there's also as of yesterday, there were 20 co-sponsors to that bill in the House. That means 20 members of the U.S. House of Representatives that are saying, I agree with this bill, I support this bill, and we expect that number to continue to go up. So from a legislative side of it, that's really positive. I think that is, it's an indication that more people are starting to learn about it, more people are supporting it. There is a concern about letting the program just die entirely. I don't think that there's a strong appetite for doing that. And I think that, we could end up with a short-term lapse. There's very little time left to act before June 30th. But I think that, momentum is moving in the right direction to see that bill, that iteration of that bill or Eb5 reauthorization get pushed over the edge. One thing I would also add to what Kurt said is this bill is kind of chock full of additional measures that I think will help the industry, that I think will help the investors, and will help hold regional centers accountable. One of the most simple, straightforward things is that it's actually going to mandate and require that regional centers file an application for approval before the USCIS will start adjudicating I-526s. And so why that's important, it means that it will level the playing field. Right now, there are regional centers out there marketing projects with 924 pre-approval, and the hope is that if that petition, which is kind of a half petition, if you were, it's a business petition, doesn't include any investor information. But what happens with that petition is once it's approved, the USCIS will typically grant deference to any investor's petition that's filed. They're going to kind of, regulate that process in that they're going to require it. And that will hopefully help them speed up processing times. It will let an investor have a little bit more confidence that the project that they're subscribing into kind of passes muster with USCIS. They're also going to put in other measures that require investors to audit and be more transparent with their information. We already audit. That's something that we're already prepared to do, so it'll be an easy transition for us. But things like that, I think, are going to be hugely important. So not only are you going to have kind of the requirement that all these Eb5 investments comply with securities rules, but you're also going to have a different layer of investor reliability through transparency that the regional centers will have to provide, and then also a little bit more transparency on what the U.S. government is going to think about each one of these offerings, and that the regional centers are going to file those applications in advance.
Let me ask you a different question, Matt. I haven't asked you before. If you were an Eb5 investor, invested in a project other than through CMB, what questions would you be asking the regional center about your investment? When we're talking about these integrity issues, how's the project doing, auditing, what questions would you be asking your regional center about your project?
Yeah, so this is a long list, and I'll try and hit on the things that kind of most align with what investors' goals are. And number one goal of any investor is to get their green card. So you got to focus on whether or not that offering has been properly structured. And then to kind of help, get comfort with that, I'd be looking at the track record of that regional center. Have they filed these types of petitions before? Have they used the same structure? Do they have I-526, that initial approval? Do they have approval that allow the investors to remove their conditions? Those sorts of things. And then I'd be looking at what measures do you have in place to ensure that job creation is going to occur. Then you get into the project side of it, and that comes to the investor's second goal, return of capital. You're looking at the developer they're working with, the track record of that developer. How's that investment been structured? Is it a loan? Is it equity? What are the terms of that loan? Is this regional center going to enforce the terms and conditions of that loan agreement, or is this kind of just like a weird exchange between an entity that operates on both sides of the equation? We see those in Eb5.
Let me ask you a different question. Actually, this is a better question. I'm going to come right to you with this, Steve, in a second. But maybe this is a better question for Kurt. Either Matt or Kurt answer this. So if I'm an investor and I'm already invested in the project, how can I know how the project's doing, right? I get updates from the regional centers. We've all seen them. They come out. how can I know what's really going on? And, if there's really something that I should be doing or sort of paying attention to with my existing investment. So either Kurt or Matt, you're welcome to attack that. You're muted, Kurt.
Here, real
Yeah,
quick, I'll
go
jump
ahead.
in with just one minor comment and then I'll turn it over to Kurt. Go take a look at the project. If you have, the regional center should be providing you updates on the project, what's happening, status of construction, status of operations, but go visit it. If you can't go visit that project and lay eyes on it, and the regional center isn't going to help you or accommodate you in your efforts to do that, that in and of itself is a problem. So, it's kind of the trust but verify side of it.
The story I always tell is when I began my legal career, I wanted to do something called commercial mortgage-backed securities, which at the time was very hot. Now it brought down Lehman and it's a different issue. But I thought I was going to do these big, sexy deals as a young lawyer. And the first thing the law firm did was present me a pair of Wellington boots, kind of as a joke. They do for all of their new associates, and said, the most important thing, you might be dealing with deals of billions of dollars and thousands of pages of documents, but still the most important thing, step one, is you put on your Wellington boots and you go walk the project site to see it's really there and that it really makes sense. So anyway, Kurt, would you like to come in on this?
I think Matt did a good job. And I think your story about site visits, I would totally agree with you, Mark. We learn so much. We go through all the documents. We're looking at things that Matt was referring to, like the senior loan and intercreditor agreements, and we're looking at permitting and making sure everything is the way it should be and the way it's said to be in the PPM. And frequently, by the way, it's not. But that's our first role, is to really feel like we understand.
PPM, Kurt, what's the PPM?
The private placement memorandum. These would be the documents that'll define exactly what your rights are and what the responsibilities of the project are. But then once we've gone through that and we go do a site visit and meet with management, so frequently we understand the deal differently. And sometimes it's an enhanced understanding, and we can see clearly the demand generators, meaning the things that are going on around the project that are going to bring demand to that project, or we realize this is not the project that it looks like on paper. So now after you've made your investment, now you've made your investment, and I'd still think that your point and Matt's point about visiting the project can be very helpful. We add a layer of advantage to investors in that we do progress reports. We do regular reviews of projects. And so you at least have an advocate in us to look at the progress and to help you determine that it is, that we think it is what's being said, or if we find some problems, we'll point those out. So, but I think generally after you've made your investment, yeah, you want to know what's going on. But to a large extent, you're in that investment for 5 years, and there's not much you can do.
Asif, I want to ask you, but I'm going to warn you. The next topic, because lots of people are asking it, are what are the consequences if the program lapses on June the 30th? So first of all, I want to hear your views on what Matt and Kurt have just spoken about very well. Perhaps as an investor, also working for, your regional center is also, like CMB, been around a very long time and been very successful. So with those dual hats. But then I'm going to switch it up and I'm going to ask about what happens if something bad happens at the end of June. So let's start with the first topic first.
Well, absolutely. Thank you. So I won't take much of the time. I promise you that. But I completely agree what Matt and Kurt said, and especially in simple language, in a simple term, my experience says that if you are with a good regional center, that means you are in a good hand, because that the good regional center means having a fantastic track record, history of completion of the project, history of the repayment of the the capital to the investors, creating a full amount of jobs, and of course the developer background as well. So for example, our current project that we have in Milwaukee, that is it's a Hilton project, and we have the developer who has done the 4 projects already in past with us, and it got 100% track records of converting all conditional green card into the permanent green card. That means all jobs has been created successfully. So these are the key factors. But once that, keeping those things sidelined, I would like to add one simple sentence that will give a right thing. to my listeners, to all the listeners, trust factor. So whatever the due diligence you are doing, whatever, specific things you are taking into the consideration, if you are having minimum of the 5% trust factor with your regional center and developer, then and then you should only proceed with the Eb5 thing. If you don't have that trust factor, I will strongly believe, and I can strongly say that, please do not do that, because that's trust factor, and then you would be able to put your money into hands of the different people, right? And then you're you're pursuing the dream of coming to the United States with the right channel, with the right regional center, with the right Eb5 project. So that trust factor is the most important thing. And as far as the project questions and answers are concerned, I completely agree with Kurt that once you are in for 5 years. There is nothing you can do about it. But before, of course, you have an option to go to the project. If the project is in the early stage, at least you should know what exactly is going on. The PPM document, as Kurt said, you have experts to read the document for you, and you can take an idea what exactly, because the conversation you are doing, if you are dealing directly with the regional center, the most important thing, if you are dealing with the regional centers like CMB, First Pathway Partners, and in one of the top other regional centers, definitely the trust factor is definitely there, and you have got the track history. They have not done nothing wrong so far, and they will not do nothing wrong so far in future as well. But again, that doesn't mean that the story cannot be collapsed or something like that. So again, the trust factor should be there. If you have a chance to visit the project personally, you should visit the project personally. If you don't have a chance, definitely there might be some sort of arrangement from the regional center, or if you have got any relatives back in US and you are in India or any other country, or the attorney may help you in that case, and to learn more about the project's feasibility and viability. So that's the case as far as my first question to my regional center, if I'm an investor, about the feasibility and viability of the project, safety of my capital, safety of my green card, and of course, the conversion of conditional green card into the permanent green card, and that is related to job creation.
One of the points I like to make is to clients, some of what you're talking about or looking at stuff, is understand what different professionals do. An Eb5 lawyer is an immigration lawyer. They're not going to go through the project like a real estate investment lawyer would. If you're representing Goldman Sachs or Lehman, as I used to, well, my firm used to, let's correct that, earlier in my career, they have real estate finance lawyers to do that. They don't bring in Eb5 lawyers to do due diligence for major financial institutions on real estate projects. So your Eb5 lawyer isn't going to tell you about some of the things that
No. I'm not asking to get an opinion from the Eb5 attorney. I'm asking to make an arrangement if there is some way that the investor can at least go to the project and look into the project, may get some sort of help from the immigration attorney, not the recommendation from the immigration. Of course, I know that immigration attorney cannot recommend about the project.
If I was investing, Asif, I hands down, just independently, I would hire a real estate lawyer in addition to an Eb5 lawyer who's used to looking at those kinds of projects. They won't do what Kurt does. Kurt's the financial genius on this panel who can guide people through the financial analysis, and a real estate lawyer won't do any of that stuff. You need Kurt. But a real estate lawyer will walk the site for you. They'll look at the lending documents, and they'll perhaps flag legal issues, because a lot of these projects have technical legal issues in the lending language, which is not in the scope of immigration or Eb5, but it's very much issues that may put your capital at risk. And it's especially true if things start going wrong with a project. An immigration lawyer is not a workouts lawyer. There's an area of law called workouts, and investors and people in these projects are typically represented by workouts lawyers, and they know their ways around these deals. And they know how to, even though you think you have no rights, if something starts going down, actually that's not true. And there may be things you can do. So anyway, I'm just sort of making a point. I'll let you continue. I apologize.
You make a good point. You make an important point. Right now, there's a lot of very busy securities lawyers in Eb5 doing workout work. Asif, I'm going to disagree with you on this one. I think most of the fraud, most of the problems we've seen in Eb5 have resulted from people trusting someone else, as opposed to knowing what they're getting into. So I know your outfit, and I think it's a first-class outfit. But every deal is different. Every deal that you do is different, and every deal that you do should be analyzed carefully. And once trust starts to be the deciding factor, for me, it means you haven't done your homework, because trust should be that last little element. I know what I want. I can see that this is offering me the terms and the structure that I really want. And do I trust these people? And that's the way, that's the way we kind of organize the process, is that once they've had a chance to look at all of the investments, again, we only put what we think are the best investments on the marketplace. And we do that after careful analysis. So we'll look at 50 deals. We've got 12 right now on the platform. You can look at those 12. You can get a good sense of what you like. But before you make a decision, we always structure a call with management so that you can decide, is this a person, or are these people that I want to deal with for the next 5 years? Are these people I can actually feel that I can trust? But it's that very last element to me.
Unfortunately, you absolutely misunderstood me. What I just said earlier, that first of all, you're absolutely right. You need to know what exactly going on, what exactly are the offerings are. And ultimately, if I am not into the, global clients, I'm more into the Indian clients. And ultimately the final question comes, everything is perfect, everything is good, everything is nice. But final question, can we trust these people? So that's why I said 5% trust factor will be required at the end of the process, that you need to trust them. Ultimately, because you are giving away your money, you're putting the money in the hands of other people, and you need to have that trust factor based on the track record, based on what they have done in past, how that the success stories in the past, how many they have conditional green card or permanent green card they have issued, based on that fact that they have converted all the permanent conditional green card into the permanent green card. So my friend Kurt, I said that 5% trust factor should come at last, but at least you should have the 5% minimum trust factor.
I think you're right, Asif. I think, generally in business, people want to do business with people they trust, right? It doesn't matter what industry, what business you're in. People want to do business with people they trust.
Exactly.
That said, Kurt's right. People don't read the documents. One of the biggest failings in Eb5 is people don't read the documents. Eb5 lawyer will review them and say, yes, you think you're going to get your Eb5. But there are all kinds of provisions in those Eb5 documents that people don't read. And a lot of the need to trust someone is probably obviated by a proper review of the documents and asking a bunch more questions by someone who knows what they're doing. Would you agree with that?
I agree with you. I think that what you're saying is they're not reading the documents, but the ones that are, and of the ones that are, Indians probably make by far the largest group of that. They don't always verify. So it's one thing to look at the documents and feel like you understand the terms, but verify those terms as well. Make sure that what's being said in there is completely accurate. Unfortunately, it's not always that way.
Right. Okay. So Asif, I said I was going to ask you about the sort of what happens in June. So let's start out kick this topic off with a question, because we're getting lots and lots of questions. Actually, the number of attendees after 3/4 of an hour is still going up, which I've never had before in a webinar. But so let me ask you this question: should prospective Eb5 investors not wait for the bill? I assume they mean the bill we were talking about in the end of June. And when is it likely?
So should the prospective Eb5 investor wait for the reauthorization or not? That's the question is?
Right. That's, I think that's what the question means.
Right. So yes, absolutely. So, again, people have the different opinion. I'm willing to give my opinion on that, because we believe in in the transparent process and the slow but the steady process. So yes, because of this, situation, I would definitely tell my clients because the reauthorization is going to be there or not, that's a secondary question. But right now, the kind of situation, because if I'm going to tell my client that, okay, now 18 days to go, and now you need to hire an attorney and if the attorney and the source of fund is absolutely in a legitimate condition, and if the client thinks that, okay, I'll be able to do and file the petition within this 16 or 17 days of period of time, that should be okay. But we need to understand, once the program expires, and even if the petition has been filed, the petition will be in abeyance. That means it will not be processed until the program is reauthorized. So we need to understand that fact. If the investor is willing to take that step and willing to take that risk, because anyhow, the lapse is going to be, by looking at the past experiences, when we had the lapse for like 1 month, when the government shutdown was there, and I think December 22nd, 2018 till January 2019, January 25th, 2019. So the lapse was there and the shutdown was there, but that was a temporary one. But this time we need to understand the reauthorization we are looking at the two things simultaneously. We are looking at the reauthorization for the longer period of time and the legislation changes as well. So I would recommend, if we are 100% sure, 100% ready with the source of fund, and we will be able to file, we have got the attorney retainer and we have all the good documents sorted, and we can transfer the fund within this 15 days or 16 days of time frame, we should. Otherwise, I would probably wait, because as you rightly mentioned in the beginning of the webinar, that for source of fund for Indian or any other nationalities, it is not a piece of cake, and managing, of course, there might be an exceptions cases, but again, usually it takes 15 to 25 days to maybe 1 month to 2 months of time period in order to facilitate and prepare all the source of fund documents. So that's what my suggestion would be.
Matt, you've been quiet for a few minutes. That's not usual.
Well, yeah, I mean, a few things to say to add on to what Asif said, and then a couple things that I guess I'd pick at. Number one, we're all looking into our crystal balls here. No one knows exactly what's going to happen between now and September, or June 30th. I keep saying September. We're so used to September 30th, right? No one knows what's going to happen between now and June 30th, and no one knows what's going to happen after June 30th. We may see, this bill get pushed through, and we may not have a lapse. I think we have to think in likelihoods, though. I think it's there's a lot going on in the government right now. I think it's unlikely that we're going to see it get passed before June 30th. So there could be a lapse. But where I'd pick at what Asif said, and I agree with most of what you said, but where I'd pick at it a little bit is we actually don't know whether or not they're going to continue to process the petitions that have been filed before June 30th. That's still a little unclear. We actually have no idea how the USCIS is going to move forward. They haven't issued any guidance on this. We can look at what's been said in the past. We can look at what's been done in the past. It's really not accurate to call the previous sunsets of the program temporary. They were never intended to be temporary. They sunset, and then they had to be reauthorized. And that was never a given that they were going to be reauthorized. Each time the bill had to be added onto an omnibus bill or an appropriations bill to allow it to be authorized. So, it's actually not much of a different situation that it's ever been in the past. If we see a lapse, it's a lapse. If there's potential that the government is going to revive the program or reauthorize the program, and momentum is moving in the right direction there, USCIS may issue some guidance on what they're going to do in the interim. I think most people have looked at this and said, wow, if there is a shutdown after June 30th, it would create unbelievable chaos in the program. You'd have investors panicking, you'd have regional centers panicking, you'd have developers who are reliant on the capital panicking. And so I think that if there is a prolonged lapse, we are going to see some guidance on, a wind down type process that would allow certain petitions to continue to get moved forward. That's my opinion. Again, this is all my opinion. But what we're really talking about is, everyone's best guess and what we think is likely to happen or what may not be likely to happen. In my opinion, I think that the program is far too valuable to the U.S. government. I think there's far too many people invested in this program for the lawmakers to simply just let the program end. And so even though we may see a short-term lapse, I think that we're ultimately going to see a longer-term reauthorization of the program in some form or fashion. And in my opinion, the future of EB5 is still bright. We're still hiring. This is going to sound crazy. We actually have 2 people starting on July 6th that are going to be market specialists specific for EB5. So if that's any indication of what CMB thinks, you can make that judgment for yourself. But we think that EB5 is going to be around for the long term. We're going to be around for the long term. And, we just have to see what happens with this legislation. We're going to continue to do everything we can to advocate for the program and support the lawmakers in their efforts to get this accomplished.
Right. So a few questions on this topic, Matt, if I may. So there's a guy, I won't say the last name, Rob, is asking, how long is how long is it envisaged that the government reauthorization for the EB5 program would be? It seems that in the past it was for fairly short intervals. What would the mechanism to get the Senate and the House bills passed be? Will it have to be a standalone? Does it seem like that it is feasible to happen in the near term?
Yeah, and so we touched on this a little bit. You know, the mechanism is you have to have legislation that's introduced and passed through the U.S. House of Representatives and the U.S. Senate. It could be done on a standalone basis. It's hard because there's so many issues going on right now that everyone wants to focus on. There's broader immigration reform. There's the infrastructure bill. There's all kinds of stuff that people are looking at and you know, kind of prioritizing. And so every lawmaker kind of has a different intention in mind. There's ways in which legislation can be introduced and passed on what's called a hotline, where it can get introduced and not necessarily have to go through the formal committee process. I think there's always been hope that something like that could occur, or a unanimous consent type vote, as it were, in the Senate. You know, who knows? There's different ways in which I think it can be done. The easiest way, and the way I think the approach has been, is that we're going to try and find some other legislation to associate and attach Eb5 to. And just so everybody knows, that's how it was always done for these extensions. So there's always this talk about these short-term extensions and them coinciding with the government spending bills. Well, that was somewhat coincidental in that the program always sunset on September 30th, which is the end of the government fiscal year. And at that point in time, new appropriations legislation had to be passed. And when we saw these short-term extensions, there'd be what's called a continuing resolution, where they essentially just change the date because they can't agree on, you know, a new budget and new appropriations packages. And Eb5 would benefit by getting added on to those packages. And so we kept seeing short-term extensions as is, but there wasn't an appetite in those recent, you know, in the past 5 or 6 years to extend it long-term, because there were lawmakers pushing for reform and change within the program. Right now, if we get that reform and change in the program, the goal is to get a 5-year extension. And I think that will create a lot of comfort for everybody in this industry.
Thank you. At present, or after proposed June the 30th changes, is there any possibility to transfer principal applicant name to 18-year daughter's name from her mother's name? I need to reread that. You know, whoever asked that question, we're happy to answer it. We'll get to it afterwards. Kurt, do you have anything to add about the June 30th deadline? And then I'm just going to ask, what about, you know, existing people and what impact could it have on them? But do you have any words of wisdom here?
You know, there's, as Matt pointed out, there's so many possibilities, so many different interests. Our firm is also in growth mode, and we've made a decision that we believe that the program will get authorized in the next 3 weeks. So that's the mentality that we have. And I think you have to kind of listen to people and then pick a direction. If I could file today, if I was trying to file and I could file today, I would. I'd like to get in before anything changes, but for most people, that's not going to be possible. If you're not halfway down the road right now, you probably can't. If you want to try, you've got some people on here who can probably help you, but it's probably unlikely you can do it from now. So our point of view is, I think this bearing case will disappear and become nothing. I think this program will get reauthorized in the next couple of weeks.
The bearing case, just to be clear, the bearing case is associated with the $500,000 window, right?
That's right. Sorry. Yeah.
Go on. Sorry.
No, and I think Matt kind of covered it. You know, you have to pick what you think's going to happen, and that's what we've picked. What we think's going to happen, and if it doesn't happen, then there's a lot of potential ways it goes from there, and we'll adjust based on what happens. So I think the broader picture is exciting. You've got a Biden administration that is just recently put out a 46-page blueprint on making the immigration program work effectively. We've got this woman named Ura Mendoza who said at the heart of a functioning immigration system is effective processing. So I think that so long as we get through this, and I think we'll learn, if we do this in a month, we may know a lot more than we know today. It feels to me like Eb5 is going in the right direction, but unfortunately, I can't give people a lot of comfort in what's going to happen over the next few weeks.
So there's a lot of questions about project due diligence too. If I want to do Eb5 quickly, maybe because of this window, maybe for a completely other reason. So I need to choose a project quickly. How does your platform help me, Kurt?
Well, I think, first of all, your platform of an escrow service is very helpful. Getting your money into the U.S. and making sure that you can deposit it into an account quickly is very important. And source of funds, again, Mark, you're an immigration lawyer is going to have to evaluate the source of funds and make a decision. Can we back this up relatively quickly, or can we at least get an application in that we can then go back and file some updates to? As far as picking a project, it's easy from my point of view. We give you access to the platform. You review all of the terms. You can view a site visit video. You see the strengths that we pointed out, the risks that we point out, and we even rate the deals. And ultimately, we've seen people make a decision in 2 or 3 days, and that's an educated decision. So the investment selection is probably not the problem. It's probably more about source of funds and getting your money out.
Right. Okay. I'm just reading some more of the questions quickly. Okay, so let's just switch topic a little bit, Matthew. Question is, how will the new proposed bipartisan visa law, which removes the country per capita cap, affect the old and new Eb5 applicants?
Yeah, so this has been something that's been floating around for many years. And what the question is referring to is legislation that has, I believe, been reintroduced by Representative Lofgren, who is hoping to remove the country caps on the employment-based visas. There's a cap on each program. There are multiple programs, E1 through 5, EB1 through 5. And it limits the number of applicants that can come from any one country before any other country gets access to those same number of visas. What this would do, and what without this cap, or with this cap in place rather, what it's done is it's created backlogs in countries like China, because there is a huge demand from a country like China, and there's a limited number of visas that can be issued specifically to China before other countries get access to visas as well. So right now there's 10,000 visas in EB5. Each country gets about 700 visas. China has consumed far over their 700 visas for years and years and years. They eat up what's left over after each country gets their crack at 700, but they've also have a backlog that far and away exceeds that 10,000 in a year. Because other countries eat away at that 700, it keeps pushing China back further and further. This is particularly a problem in the EB2 and 3 categories for Indian applicants in the tech industry, for instance, who are hoping to immigrate to the United States, but have, in some cases, 100+ year wait times before there's going to be a visa available to them. There's been a lot of people pushing to remove those caps, so it would just be one line, one first come, first served line, which would change the overall backlog for people looking to immigrate from specific countries. How this would impact EB5 is that it would, right now there's about 80,000 total applicants in line. The vast majority of them are Chinese. If you moved them all into one line, it would mean that any new applicant would sit at the very back of that 80,000 investor line, roughly creating about an 8-year visa backlog for all countries in EB5. And that would, the way that the legislation introduced by Zoe Lofgren has been written, it would impact all investors who have already placed a petition on file and are pending visa availability, and any new applicant, any new visa applicant. So for any new person, it would create about an 8-year backlog. For any person who's already in line, depending on where they sit in that line, it might speed their process up. It might push them back a little bit.
Great, thank you. So we've been through sort of the two of the pending pieces of legislation, talked about sort of the impacts of June the 30th. Asif, is there anything in what we've talked about that you'd like to highlight or go over? And then we've still got a lot of sort of, I would say, random questions, and perhaps we can spend a few minutes on those. But in sort of the context of what this panel was built to be about, is there anything you'd like to add or comments you have?
No, well, we have fantastic panelists in the form of Kurt and Matt. So yeah, they have covered most of the part of it, and there is nothing more to that needs to be added over right now.
All right, awesome. So why don't I ask you one of these questions? India is not currently in retrogression. What happens if I file, says it must be an I-526, and then India goes into retrogression? I think that's a straightforward question to see.
Yeah, absolutely. So that means retrogrations means you need to wait until your visa is available. So even if your I-526 petition is approved, right now it's current. Current means the visa is available. You can simply, the moment you get your approval of I-526, you can start the process of consular as well as embassy process. So that is not going to be a delay for you. But if, let's say, for example, the retrogression is going to be there after 6 months, 1 year, or maybe 1.5 years at the time of your approval, then it's a simple logic that when you have to wait probably until and unless your priority dates become current and your visa is available, and then you'll be able to start the consulate process. Luckily, we don't have any retrogression in Indian market right now, but who knows? But right now, yeah, there is no retrogression. But if there is a retrogression, then you might have to wait till your date becomes
And how does retrogression link into what Matt was just talking about?
Sorry, what was that?
I said, how does retrogression link into what Matt was just talking about?
Well, if it is the case, then as Matt, there might be delaying in the processing time as well. So if the entire cycle is going to be delayed, it's not only about the retrogression, or it's not about the visa availability. It's about the entire cycle of the adjudication of the processing time of the I-526. Right now, because of the COVID situation, it's already been quite a significant delay going on, right? But what I personally believe, and I may be wrong about it, but I personally believe over the period of time, as the things will be going back to the normal thing, so the processing time will improve in future as well. But as far as what Matt says, so that is affecting the entire circle, not only the consular process, but the entire circle of the processing time. So over and above, it will be an extra waiting period for the petitioner in order to get the approval.
Yeah, and one thing I do want to add to what I had said too, because it would be unfair to not provide some additional context to it. One thing is that's important to understand is that although there are, estimated 80,000 people in that backlog, there are very few new filers. And so we do expect huge numbers to come off of that backlog year over year over the next couple of years. The other thing that's benefiting the program, and Charlie Oppenheim, head of visa control for the U.S. State Department, just spoke about it, is that when there are visas in the family category that are unused, they actually roll in to the employment-based visas. And so next year, it's actually anticipated that the program may receive over double their normal allotment of visas, which again, would carve 2 years off of that backlog if there's very few new filings. And so even though, as it were today, this second, if it were to come off, one would look at it and maybe call it an 8-year backlog. I think very quickly you'd see that backlog go down. And frankly, it'd probably start to coincide with about the same investment timeline that investors go through anyway. How long it's going to take them to get through the process will probably match up with when they're eligible to get their capital back and loans have been repaid and the projects have come to fruition. So, when you look at it from that context, it's not necessarily the issue that an 8-year backlog or, China, who has a 17-plus-year backlog, that's a whole different concept that will likely never impact India.
So here's a question specifically for CMB. You mentioned 500K investment now, and then after 18 months-ish, I'm not sure I heard 18 months, but regardless, after 18 months-ish, remaining 400,000 if legislation doesn't change. Is that option on offer with CMB, essentially, is what this is saying, to just change the wording a little bit?
Sure, I'll add some caveats to that. So what our offering currently allows for is for an investor to move forward with a partial investment and then a promissory note for the balance. Right now, the law is the law, the rules are the rule. The investment amount is $900,000. And so if you're going to file, you need to file with a petition that's provable. And so us as a company that's going to allow you to move forward with a promissory note, we're going to want to make sure that you're able to actually fulfill that full $900,000 investment, or else we're putting forward a petition to the U.S. government that isn't, that's not worth its time. And so that's really the structure that we'd be looking for. 18 months, we'd have to look at that term. If you're interested in this is something that you should reach out to CMB right away. We can start talking about that process. If you're capable of moving forward at that 900,000 with that promissory note, and that's a structure that works, that's something that we could probably accommodate right now. Now, if you're an investor that really is only interested at 500,000, although our offering allows you to put in a partial investment, we're still going to require that promissory note right now. So in that situation, you'd want to sit tight and wait for for news on the bearing suit.
Right, makes sense. And I want to reiterate something I said earlier. You have to be very careful with partial investment. When we've done it, we've set up sometimes an escrow account outside the United States to allow for foreign sort of currency control. So, some of the investment, some of the partial investment, the funds are really identified. Sometimes a guy from India is using partial investment because under FEMA, they can't get all of their money to America in 1 year. So they leave a little bit of it behind, but it's locked away. And USCIS want to see that you're fully committed to the process. Partial investment is allowed, but you really want to lower your risk by identifying the source of funds. There are other ways to do it, but safest way, I think, is to put the money into escrow or some other mechanism. So it's clearly pegged for EB5. And I think, you have to think about the immigration card risk. And I know you guys at CMB do that. So Asif, what is FPP's position on this, and what are you guys doing with it?
Sorry, your voice was breaking, so I didn't get the question.
I said, what is FPP's position on sort of this question? Let's suppose that it said FPP and not CMB. How would you answer it? Are FPP facilitating this?
So I would answer exactly the way Matt said that, if you are having the commitment for the $900,000, then we will, advise you to proceed further, because you never know what's going to happen in the future as far as the legislation and the different rules are concerned, right? So probably you should be ready with the entire $9,000, source of fund things, and with the promissory note, if $500,000 is available and you're going to investment now, and then we're going to see the situation, how the situation is going to pan out. On the basis of that, we'll be able to take the decision. But unless and until you are completely ready with this $900,000, we won't recommend, and we won't, ask you to, move further, because right, as everyone knows that we don't have a crystal ball with us, and we don't know what's going to happen in next coming future and next coming days. So we definitely should be prepared for each and every, aspect of the scenario. So, the simple recommendation is, if you are willing to move forward, then probably you should be, fully prepared with the entire source of fund. You never know if the situation, allows us to, accommodate you in the $500,000. We are happy to do that. But if not, then in that case, you are, 100% ready with the remaining $400,000 with the complete source of fund ready. So in order to, carry on your entire petition in an appropriate and smoother way.
So I'm going to ask this question to Asif, to Matt, and then for Kurt for a sort of general market view. Someone's asking about, when can I get my money back? Is it typically 9 years? This can actually be a complicated question, but there are two elements to it. There's immigration law and rules. When can you get your money back and not get your green card? But then there's the, if you like, commercial contract with the regional center, isn't there, Asif? So what sort of terms and conditions does sort of FPP have on this?
Well, as far as the the terms and conditions are concerned, the people, different regional centers have the different things. Let me give you my example first, and then I'll come back to the main thing. But when I applied for my EB5 petition, the terms and conditions said over there that you need to be completely finished your conditional residency of 2 years. The loan needs to get matured that you have paid for, and you need to apply for I-829. Now, in some of the other regional center, there might be a conflict or the other statement that you need to wait until your I-829 gets approved, right? So you need to understand these two factors, that you need to read the documents. The PPM document, it will be clearly mentioned. In my case, it was written, and that's how, the moment I got my, finished my conditional residency and I got my 829 applied and the loan get matured, I got my money back. So I don't need to wait till I-829 got approved. I just, got my money back the moment I applied it and I finished my conditional residency of 2 years and the loan got approved. The same case, the FPP has having the same stance. The money gets, will be given back to the investors if conditional residency is completed, and if you have applied successfully for I-829 and the loan gets matured by the funds are available.
There's a caveat on this, isn't there? That the project has the money available. So whilst I don't think it's happened to either CMB or FPP, there are certainly projects in the market where, you know, perhaps the hotel doesn't have the occupancy it needs or whatever the case may be, where, you know, the contract may say you can have your money back, but at the end of the day, if the project doesn't have the money to give you back, you're not getting it back, right? Or at least you're not getting it back on time. Correct?
Absolutely, that can happen. That is the reason why you need to go through the documents carefully. What exactly mentioned in the PPM document, you need to completely go through that word by word, sentence by sentence. And there might be, see, for example, who knows, the COVID situation was going to be there in the year of 2020, right? So over there, every math, every calculation just collapsed, right? So
I'm going to disagree with you a little bit. I think the COVID excuse is absolute balderdash and slapdash craziness, cover-up job for people who haven't structured deals properly to protect investors in a downturn. Now, I'm over-exaggerating a little bit. Clearly there are projects that have gotten into trouble because of COVID, and it's understandable and reasonable. But it gets me agitated where I see projects that are really badly structured in terms of the way they protect an investor's legal rights, the way that they move things around the priority of investors versus other creditors and things. And it's structured that way up front. And then guess what? When the wind starts blowing, investors get into trouble and they have no protection. And it doesn't matter whether it's a COVID wind, a 9/11 wind, or any other kind of wind. It's just a poorly structured project. So, I take back what I said. There are certainly projects where, COVID is the issue, but there are also projects where COVID is just a convenient excuse for a badly structured project. So, Matt, do you agree with my sort of probably coming down on this too hard?
Yeah, I mean, we used to have people that would ask us, what's the worst case scenario in this project? And we'd say something really crazy like, without, assuming there won't be a North Korean missile attack on the West Coast, you got to think about these crazy situations to think of your absolute worst disaster situations. But reality is that, especially the hospitality industry, COVID shut the doors of hotels. Look at the West Coast. I mean, we did a project in Garden Grove, California. It's a Great Wolf Lodge Hotel and Resort. And luckily, we're long out of that project. Our full loan has been repaid, but we're still in contact with that developer, and it reopened, I think, last week after closing in March of last year. And so projects that's closed for 15 months, that's going to have devastating results on their ability to service debt, repay that debt on time. You look at new appraisals of properties, they've lost massive value. You look at what appraisers are saying. These are national appraisers, right? These are not yahoos that are just making stuff up. You look at national appraisers that are looking at certain asset types and saying it might take until 2024 for certain revenue streams to recover and things of that nature. And, there are ways to protect yourself and to keep yourself viable in those situations. But there is no foolproof way to prevent, tough decisions from needing to be made in situations like that.
Compare, for example, like a hotel in a trendy area on the West Coast to, your warehouse that's got a, I don't know how many years lease, 20, 30-year lease from, let's say, a AAA credit rated institution. So the money, I can't get into too much because we're getting into financial issues, but I can look at the lease as a lawyer and I can read the lease. It would be the practice of law without a license and possibly a criminal offense for a financial advisor to cast an opinion as to the enforceability of that lease. If that lease is enforceable, and I guess if you think that the tenant is secure, that's a pretty good deal. It's pretty COVID-proof. It's pretty bomb-proof.
Yeah, and that's, we've focused on that asset type really since 2012. We've had other projects and other asset types. We kind of look at every asset type, but we've certainly tightened up our practices as a company. I think most regional centers have done that. You're avoiding, or at least you would hope that people are learning from their mistakes and structuring on some of these others. But from CMB's perspective, we're looking at projects right now that you just mentioned, Mark, that are pre-leased, 15+ year leases in some situations by, credit tenants. And in many cases, there's previously structured, sale agreements for those down the road. We're working with developers who have the ability to execute and have proven that ability even through, you know, the 2008 financial crisis, through COVID. And those are the types of assets and the types of developers that you want to work with right now, certainly to kind of avoid those sorts of issues, no doubt.
So Kurt, you're sort of the master on this topic, so I'll let you speak to this. But we just dropped down to 66 participants. So after Kurt's spoken, I'm going to ask each of our panelists to think about their sort of departing words of wisdom on the future of EB5. But Kurt, please go ahead. You're mute, man.
Yep, sorry.
Yeah.
You know, it's a difficult question. I think, first of all, Mark, to your point about, you know, we saw Hudson Yards come out in March, I think, of 2020, announcing that they weren't going to make any payments on EB5. You know, COVID had barely begun. And, you know, so you get a sense that maybe that deal was struck in a way where the terms were lopsided to the investors, against the investors. And I think that that group took advantage of the terms. When I got into EB5 in 2013, what I was struck by was that most of these deals were structured with securities attorneys hired by the regional centers with no input from the investors, because frankly, no one really, if the investors bought, then the stronger the terms that benefited the regional center, the better. And you'd think, well, the agents were supposed to look after their clients, but they didn't. They were more interested in what kind of fees they were getting. So we've been in an industry and era of deals that were one-sided. Now, I will tell you that none of my clients have struggled at all with their investments post-COVID. And it's probably because we look at deal structures that put the investors' security interests in such a high position that even if the deal fails, they're still going to get their money back. No one could have possibly seen COVID, and I've never seen it in a disclosure of anything like that, even though we've had crazy disclosures like there might be a hurricane here in Puerto Rico. And lo and behold, there was. That was quite an interesting disclosure that we were getting so much pushback on because there hadn't been a hurricane in Puerto Rico in 100 years. So, you know, you have to take these things in a whole. And if you're signing into a deal because of everyone else is in that deal, because the agent tells you it's a great deal, because of they've been doing it for a long time, that's a dangerous position in my mind. If you put yourself in a position where you really understand what your risks are, and I believe there are deals with very little risks, you will probably not, well, I can't say what's going to happen because I am a securities professional who is very limited as any promises I can make. But I do think doing your homework goes a long way.
I want to make one sort of point. The difference, you know, people talk about securities lawyers, but, you know, the role of a securities lawyer is almost, it's if something goes wrong. Because a securities lawyer is looking at sort of the PPM, the information that's been disclosed, and is deciding if there's a breach of the securities laws. The securities lawyer is not an expert in lease review. No securities lawyer is going to opine on the integrity of a lease because it's outside their area of expertise. Securities lawyers are experts on what needs to be disclosed and what are the consequences if they're not disclosed. So they're not the ones who are actually doing the sort of real estate deep dive of a lease.
No, they're drafting the documents. Their interest is protecting their client, the issuer, not in protecting the investors. It's the investor who needs to bring the expert.
Correct. So anyway, with that said, we're down to 64. We're dropping down now in participants. So let's have some departing words of wisdom. And Asif, I'll let you go first, and then Matt, and I'll let Kurt finish.
Well, thank you, first of all, Matt, Mark, and Kurt for your wonderful time and for giving me this wonderful opportunity to be part of this particular webinar. I really appreciate that. And as far as this entire conversation and discussion is concerned, you know, I strongly believe that EB5 is going to be the most popular, you know, immigration program, investment immigration program across the globe in future as well. And it has got, you know, supporting things. So things will be back on track. And we're going to be a nice and steady future ahead for the EB5 industry.
Matthew?
Yeah, again, thank you, everybody. This has been a fantastic panel, a lot of different viewpoints, and, you know, I think great professionals on this. And thank you for everybody who joined in to hear us talk a little bit about what's happening right now. I have mentioned it before. I think the future for EB5 is bright. I really do. And our company feels that way too. We're going to be around for a long time. We have alternative investment platforms that are going to keep us busy no matter what, and they'll exist alongside EB5. We're optimistic that we're going to see reauthorization of this program in some form or fashion. And, you know, we do what we do, I guess is an easy way to say it. When everyone was kind of panicking about the regs, we already had a pipeline of projects lined up that were going to qualify under the new regs. Right now, we have flexibility to look at investments if the bearing suit we mentioned moves forward, if the new legislation that has been introduced by Senators Grassley and Leahy has passed. We're going to be prepared to quickly adapt and keep those out. And guess what? If there's anything new out of left field that gets introduced with new requirements, we'll be prepared for those as well. We have a great team in place, and we really look forward to continuing to be a huge part of this industry. I don't know everybody who's on this panel. Obviously a large audience from India, but if you're an American audience or you're in the United States, now is the time to keep pushing those congressmen and senators to look at EB5, educate them on EB5, and push them to get on board with the Grassley and Leahy bill. I still think it's our best chance of getting long-term reauthorization and putting in some measures that are going to be great for this industry, that are going to help both investors. And then I think we'll also, in the long run, help regional centers. So that's my final 2 cents. Thanks everyone for joining.
I'm being reminded we didn't talk about consular processing, but let's have a separate discussion about what's going in the consulate. We'll bring in someone, hopefully. We work with AmCham in India, and they're hoping to get someone from the consulate in Mumbai in, and we will try and do the same thing in Ho Chi Minh City, Vietnam. So that's possibly why I left that little bit, and then we'll invite some of the panelists back, and hopefully we can have a deeper insight into sort of what's going on with consular processing. But Kurt, sort of your thoughts on the topics we've been talking about?
Sure. I see this last question where Krishna asks, does he need a real estate lawyer as well as a securities lawyer and an immigration lawyer? You don't need a securities lawyer. And I don't think you need a real estate lawyer unless you make a decision that you want to invest in a real estate project. Keep in mind, there's a lot of different projects out there. Manufacturing becoming much more popular. There's some other industries that are getting into EB5. So first figure out what deal you want to invest in, and then make sure you have the right people counseling you.
A lot of the projects are the real estate projects, right? The warehouse project, it's a real estate project. Hotel project it's a real estate project. And I told you before, Kurt, we've come across 2 deals where there's no construction permits. And guess what? The regional center didn't tell anyone because they don't have to. The immigration lawyer didn't check for it because it's a real estate issue.
Right. Well, I'll tell them if they want to ask. But, as far as this program is concerned, people from India, Asif alluded to it before. India has been on that verge where we thought they were going to go into a delay, and then it didn't go into a delay. And then we had the COVID, which made it even less likely to go into a delay. But India was clearly a couple of years ago the country of the future for EB5. And I think that's more true now than ever. I mean, the issues that we're seeing in India are going to accelerate the interest in this program. So once these issues kind of get resolved, I would suggest people to be ready. If you want to do EB5 for your children or your family, and you want to move, I believe the program is being redesigned with your interest in mind. Faster processing, potentially loans that can be made available. You've got this partial, I know Mark's not a big fan of it, and I understand why, but it's a possibility. But there is this window of opportunity to get in while India is current, so that when your petition is approved, you can then get your consular interview versus waiting, and maybe waiting a couple of years. So I would be ready. If you're interested in this program, I think it's going to get to be a better and stronger program with more protections, with faster processing. And right now, I'd say 70% of our inquiries are coming from India.
Right. So next up, conferences for us will be, I think the next one's going to be on maintaining your conditional residency. And maybe we'll have some of the same panelists. And then after that, we're going to talk about consulates. And as I explained, we're trying to see if we can get, if it's possible to get someone from the US consulate in Mumbai on our webinar. So questions, if you have questions, please feel free to contact any of the panelists. If you don't have their contact information and want them, just ask a question and we'll certainly give it to you straight away. Thank you very, very much for your time. And I know we didn't do all questions, but please, please, please ask them and you'll get the advantage of an individual answer from whomever you choose to ask. Thank you very much and have a good evening. Take care. Bye-bye.
Bye, everybody. Nice job.
Bye-bye.